If you stay interested in the law and you stick around long enough, you'll come to realize that Massachusetts thinks they are better and smarter than the federal courts and the courts in all the other states. It's a common theme. I'll explain. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Yesterday, there was an issue of admitting a prior judicial opinion on the reliability of expert witness Ms. Hyde, where a Maryland court had found her opinions unreliable. Now, that's pretty significant because it calls into question the veracity of her findings. In this case, if her methods were unreliable or found to be unreliable in another case. But the court in Maryland was applying the Daubert rule. That's what's not stated in any of the argument here or in any of what passes for judicial reasoning, but that's the reason why it was excluded, if you want my opinion. In fact, pay attention to the way that the judge introduces this subject and asks Mr. Alessi to argue his motion. It's almost like, oh, I've already made up my mind, but go ahead, rattle the ceiling rafters. We'll see what shakes out.
So I want to talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what.
Now, Mr. Alessi argued for the admission of the opinion, stating some of the following. First, he said it was mandatory under Rule 39A.
Your Honor, I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate...
One's a Massachusetts case, so that's easy enough.
Okay, so, and that's a shall...
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course a court is judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence.
State versus Herrera as a decision of record from a court of competent jurisdiction in another state, according to Rule 39A, shall be competent evidence in Massachusetts under Massachusetts Rule of Criminal Procedure 39A1. Mr. Alessi presented a certified copy of the decision, arguing that once authenticated with a seal, the rule makes its admission mandatory. He contrasted this with Rule 39B, which deals with judicial notice of foreign law and includes a materiality clause, arguing that the absence of such a clause in 39A means relevancy or materiality arguments are precluded. Just admissibility is covered in 39A. He said it was relevant to the expert's reliability and to her methodology.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what...
In one area, right? One specific area?
Well, you can call it from...
The decision.
Right. Oh, yeah, just what's in the decision. But there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking me to allow.
If I could give you the answer, Your Honor, I will explain it. It's a very short answer.
Okay.
What I want to do is, with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
The core of the defense's argument was that the Herrera decision was relevant for cross-examining Ms. Hyde on her reliability and the reliability of her methodology. They argued the Herrera decision found Ms. Hyde's expert testimony in that specific case regarding certain data forensic issues, specifically frequent location history and significant location data, not reliable. The defense highlighted that the Herrera decision discussed the issue of relying on tools or surrogate methods when the underlying Apple source code is proprietary and inaccessible. The Herrera ruling on the unreliability of her methodology in a similar context was therefore relevant to questioning her methodology in the Reed case. Mr. Alessi stated that the right to cross-examine an expert on their methodology's reliability is fundamental and not limited to Daubert hearings.
If I could, Your Honor.
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I put, Your Honor, in the Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says, the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them. In this case, it's just basic cross-examination.
Alessi then makes a very articulate argument based on the confrontation clause in the Constitution, or I guess actually in the Sixth Amendment. What he's arguing here in this next segment is you can't hamstring my ability to cross-examine this witness by excluding something on the basis of relevance when you can't possibly know if it's relevant until she's testified and I cross-examine her, which is a brilliant argument. Sadly, it doesn't seem to have had much effect on the judge.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here is the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witness has said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? That one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term downwardise anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, in any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court.
He's right there. You absolutely have to have a right to go to the bottom of the expert's methodology to determine whether its reliability. And anything that casts doubt on its reliability, like, I don't know, maybe an opinion from a sister court, should be admitted to challenge the reliability of the opinion in the Reed case. More importantly, the reliability issue was directly related to her testimony. In other words, it wasn't her final opinion they deemed unreliable. It was her methodology resulting in that opinion. So you can see how that would be really important in this case. Now, I know this is going to shock you. It just shocked me too. Not really. Judge Canone excluded the State versus Herrera decision from evidence based on Rule of Criminal Procedure 2, which pertains to the purpose and construction of the rules. So, Rule 2 is about how you interpret the other rules. It's not a rule that governs admissibility. It's a rule that tells you how to apply the other rules of criminal procedure in a particular case. It's a word, like I said, it's a rule about how you read the other rules. She stated that none of the purposes outlined in Rule 2 would be served by the admission of the Maryland trial judge's decision. These purposes, as described by the judge, are to provide for the just determination of every criminal proceeding, secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Now, this opinion was just released in March. one of the things that these guys would have done prior to, preparing for this case is they would have backgrounded this expert. They probably found that in March. They probably didn't have very much time to get it into the court. And according to the judge, it was offered without prior notice to the court. And as a result, the purpose of Rule 2 would not be served by introduction of that evidence. That was the stated reason for her refusing to admit the evidence, the lack of prior notice. You might wonder how she could get away with that. Well, first, Massachusetts has this rule that handicaps the defense in its rebuttal of witnesses, not just expert witnesses, but all witnesses. In Missouri, in a civil case particularly, but also in a criminal case, if you know that a witness, Mr. Doe is going to come and he's going to testify, and you know that he was convicted in another state for domestic violence or perjury, for example, you don't have to put that in with your discovery, because if he doesn't testify, there is absolutely no need for you to bring that in. But if he does testify, your failure to have included that in discovery, in most cases, is not going to be a problem, because it's impeachment evidence. It's evidence that goes up against the individual. The theory behind not having to disclose impeachment evidence is that you don't want to give a liar time to invent a convenient story. But in Massachusetts, you have to do that. So the lack of notice about that opinion supposedly kept that out. But I still believe it was a bias toward this Massachusetts belief that Daubert is unsound in some way. Daubert, properly applied, is a good rule, and it works to the benefit of both the plaintiff and the defense in a civil case, as well as the defendant in a criminal case and the state in a criminal case. If you can get over the reliability hurdles, then your evidence comes in. And that's a more, I guess, a freer type of approach than they like in Massachusetts. I'm sure that Massachusetts is a wonderful place to live. I've been there. I've been a number of different places in Massachusetts, including Boston. And I find the people there very interesting, very warm, nice folks. The problem that I have with Massachusetts is not the people. It's the judiciary and the judicial system that tends to operate or prefer their older 18th century origin rules and case law to more recent and more relevant and more technologically adaptable rules that are in the federal system and in most states. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.